Hey there, I'm Louisiana estate planning attorney Paul Rabelais, and in this video I'm going to talk about what this attorney needs every time I start a Louisiana succession. So it's always an intriguing time when someone dies and it's time to settle the estate. Sometimes things go really smoothly, and sometimes it seems like World War III erupts. But anytime we start the Louisiana succession, that's as we call it in Louisiana succession, other states call it probate, that process of going through the court system to get the estate settled and needing all the court orders to order third parties to transfer assets that were in the name of the person who passed away in the name of the person who passed away. Anytime we start that Louisiana succession, there are certain things that we need before we can even start. And in some cases, we need things before we finish the succession. So let me give you a list of things that you want to make sure you have really as much of this as you can before you even start the succession and have that initial conversation with the attorney. Okay, number one, first thing I need to see is a copy of the will. These days with video meetings and Zoom, it's really easy to scan a copy of the will, send it as a PDF to me, so I can at least see what the will says. Sometimes that can be done in just a matter of minutes. So one of the first things I want to see is just what does the will say? Can I even just see a photocopy of the will? Sometimes we have a meeting, and whether that's in an office or whether it's, a video conference, and we do a lot more video conferences these days because I kind of like working from home. And, I'm like, I'll be on a video conference with 4 or 5 other people. I'm like, so you'll have a copy of the will y'all can send me. And they're like, no, that's back, I think it's back at home in North Carolina. And I'm like, well, we need to see a copy of the will. So, and I'm not going to rely on what you tell me you think the will says. I need to see a copy. I'd say about 50% of the time, at least, I rely on what someone tells me that they think the will says. Mistakes happen. Okay, so that's number one, copy of the will. Number two, want to make sure there's access to the original will. What do I mean by original will? Well, it's the last will that somebody signed that would have revoked all prior wills. And we know it's the original because it's likely to have a raised notary seal where the notary put their stamp on perhaps the last page of the will. And so there's that raised notary seal. Perhaps it's in blue ink. We always get everybody to sign their stuff in blue ink so we can tell it's an original, as opposed to everything's in black ink as it comes out on a black and white copier. So when the original will is not there, then it's presumed by a judge that the person who wrote the will destroyed the will with the intent to revoke it. So not good enough, just, here's a photocopy, and we don't know where the original is, we can't find it. That's not good enough. We need to make sure we have access to the original will. Number three, let's take a look at the will and then determine who is the executor and are they willing and able to serve. So there's going to be a provision in the will that says something like, I name so-and-so as my executor, and then it probably says if they can't do it, somebody else can do it. So we would need to see who's the executor, are they willing and able to serve, because there's a lot of court activities that we've got to that have to take place, starting with getting that executor confirmed as the executor. They have to sign off on paperwork, they have to sign an oath, and we have to take all that, file it at the courthouse, get a judge to sign an order, confirming that the will is valid and confirming that the executor is the executor. So we want to make sure that executor is willing and able to serve. They got a lot to do. They're going to have to gather financial information. They're going to have to communicate with all of the heirs. So number three, who's the executor and are they willing to serve? Number four, who are the heirs? Or sometimes we call them, when we're particular in Louisiana, we call them legatees. I'll just call them heirs. Who are the heirs, and are all of the heirs alive? And are all of the heirs, can we track all of them down? So sometimes, somebody comes in and mom just died, and And mom's like, yeah, she left everything to her 4 children, but our brother, he died 2 years ago. So then we have to make a determination based on the terms of the will and Louisiana law, who's entitled to that deceased child's share. So we just need to make sure all of the heirs are alive and well. And sometimes, we run across some where, yeah, mom left something to this grandchild or left $15,000 to these 2 grandnephews. We have no idea where they are. Well, that's a problem. You got to find everybody. So we want to make sure all the heirs are alive and well. Number 5, this is the big one. Are all the parties involved cooperative? Meaning, can we all come together, take a look at all of the circumstances, including the will provisions, the assets and debts of the person who passed away, and come up with at least a framework of a plan to get everything settled in accordance with the Louisiana law and the Louisiana Succession procedural rules? Can we come up with a framework that everyone will agree with? Or is there that one person, or maybe more than one person, who is just going to turn this into a nightmare due to, who knows, due to their demands for information that doesn't exist, or they think that following the letter of law is not fair, so they want things done differently, or they acknowledge that mom's Mickey Mouse figurine set is supposed to go to all 4 children, and that one heir wants to make sure that they get their 1/4 value of the figurine set. So if all the parties cooperate, even if some parties have to give in a little on some minor issues, things will go so much smoother, so much better, so much faster than if you have only one person, typically due to poor relationship issues, that's being difficult. Number 6, what are the assets and debts of the person who passed away? Sometimes, though, we can't get that information until the executor is confirmed. And sometimes someone passes away and the heirs are like, well, this is the information that we have, but we're not sure whether he or she owns some additional stock or land or had a bank account somewhere. We're just not sure. So sometimes you gather all the information that you have at your disposal, and then once the executor is confirmed, that executor then can go to various places and various financial institutions, and they will be required to turn over any kind of estate account information or deceased person's account information to the executor, because that executor will have that court order that allows them to get it. Okay, number 7. Are the succession, are any succession assets going to be sold with the proceeds going to the heirs, such as the home of the deceased person? It's often when the home gets sold as part of the succession, and then, of course, the proceeds get divided up among the heirs. Or will the assets be transferred in kind to the heirs, such as when a person dies and they own 10,000 shares of stock in a certain company, and there's 4 heirs. And so as part of the succession process, 2,500 shares get transferred to each of the 4 children. Those 10,000 shares are not sold. So some of that conversation is nice to know early on. So I think the 2 big ones, though, are make sure you have the original will, and make sure, or to the best of your ability, have all participants in the succession come in with a spirit of cooperativeness. Hope that helps you get started on your next succession. Make sure you like, comment, and subscribe. We'll see you next time.